factors that are listed. In the event that Mr. Mayers is found guilty, the aggravating factors that come into play. Obviously, if he's found not guilty, the aggravating factors have no relevance to anything. What I want to know is whether, if there is a conviction, how you want to deal with the two aggravating factors. What I mean is, you want the jury to make a finding as to whether they're true or not, or you want to let the court, me, at some time in the future, make that decision. What about full waive? All right. In the event that the aggravating factors become relevant, you have a right to have the jury determine whether or not the aggravating factors are true. And they have to make that finding beyond a reasonable doubt. Either the jury can do it, or I can do it. Whether the jury does it or I do it, the standard of proof is proof beyond a reasonable doubt. Now, Mr. Tacopina has stated that I can make that decision rather than the jury having to make that decision. Do you understand that?
Absolutely. Yes.
Do you waive your right to have the jury make the decision and agree that I can make that decision when it becomes necessary in the future?
I think we can.
Join?
Yes.
All right. The next question is readback. If there is a readback, request for readback of testimony, what I want to know is whether both sides are willing to waive their presence and agree that the court reporter can go into the jury deliberation room and provide the readback of testimony. However, both sides will know what that readback is before it's ever provided.
I agree. We're fine with that as long as we're in agreement with what's going to be read to them.
Any communication from the jury, whether it's a request for readback or a question, will be given to both sides before any response is given to the jury. If there is a request for readback, all of you will know what the request is and will hammer out what readback will be provided.
With that, then we have no problem with the court reporter going back.
All right. Again, Mr. Mayers, you have a right to be present for the readback of testimony. What would happen is the readback of testimony would happen in open court. And you would be there, your lawyers would be there, the prosecutors would be there, and I would be there. In the alternative, you can waive your right to be present. So what would happen is, if there is a request for readback of testimony, the testimony would be provided, but it would be the court reporter going into the jury deliberation room and providing the readback, the testimony that is requested. And you won't be in there, your attorney won't be in there, the prosecutors won't be there, and neither will I. Do you understand? Do you waive your right to be present?
Yes.
John?
Yes.
All right, the last thing is, I thought that 1 hour call would be appropriate, meaning that if the jury summons that they have reached a verdict, that the verdict would be read an hour after they have made that notice. Do you have any response? Do you think it needs to be more than that, less than that?
I mean, no, it should be fine. I mean, obviously, no, it should be fine.
Oh, that reminds me. Mr. Mayers, well, under the circumstances, Mr. Mayers needs to be here within 1 hour also.
Yeah. All right.
People, do you think 1 hour is sufficient?
That's fine. If we could, an hour and a half would be easier, but if the court wants an hour,
Well, no, I can make it.
90 minutes would help us. I'm guessing.
I'm fine with that. I don't care. That's fine. Once 90 is fine.
All right, we'll do 90 minutes, and if everybody can gather before that, okay. But it'll be 90 minutes from the time that we're notified that there is a verdict. What I said to the jury, that all of you left it all in the field, I mean that. You all put out 150%. So you did your clients proud. All right, anything else to
We do have one.
Just one thing. So during the PowerPoint presentation by the people, they played the video from 1616 East Del Mar, and can't be certain of this, but it appeared to us that the sound of the first shot was played earlier on the video they showed to the jury than the one that they presented in People's Exhibit 15. So just before we leave here today, if we can just look at the PowerPoint presentation to confirm that the video was the same video admitted as People's Exhibit 15 would be fine. If the shot was actually moved, if they modified that video in some way, we'll have to figure out some type of remedy, but I just wanted to clear that before we break today. If that's okay.
Nothing was modified anyway, Your Honor. We took the videos that were admitted and we used them in PowerPoint. I do not believe that I need to sit down with counsel and go through. I think the court is certainly within its authority in ruling that that is an insignificant issue. The court has seen the evidence that's been presented, so I'll leave it up to the court.
The jury has the exhibits, so I'm going to deny that request.
Your Honor, there was evidence on it's not an insignificant issue as to whether or not the shot occurred before Relli went to Illz. It's a significant issue in this case. In fact, the people now are letting us look at it, particularly after they tried to present an exhibit of knuckles that weren't in evidence. It's disconcerting. The court's not going to let us look at it. It is what it is.
All right. I think that showing the exhibit of Relli's knuckles, I don't think that was intentional. It was an oversight. Mr. Lewin said it was an oversight. It was a mistake. We're all human beings. We make mistakes. The jury has the exhibits. The exhibits are what matters in this case, not the PowerPoint presentation. Where's Mr. Deputy?
There he is.
Oh, there you go. That's what did you want to bring anything up?
No.
Mr. Loman, anything?
No, Your Honor.
Mr. Lewin?
No, just a reminder on the caption.
Yeah, I would have forgotten.
Yeah, that's why I'm
Thank you. All right, we'll have the record.